Thank you again for tuning into today's webinar. I will now hand it over to my colleague, Laura Bryant.
Thank you, Shauna. And thank you everyone for joining us today. Thank you, Richard, for your time so you can educate us on the new legal updates that are still pending here and will be finalized in October by the governor. If you're joining us for the first time, we'd like to welcome you. If you're not familiar with Castle Group, we are a full service on-site property management company. And should you have any needs or questions, feel free to reach out to me. I'd like to introduce Richard DeBost. Richard and I have worked together at properties and have done lots of educational events together, and I'm happy to be with you again, Richard. Everybody always loves you. You're always entertaining. So thank you, and I'd like you to tell a little bit about your firm, and then we'll get started.
Sure. Thanks for having me. I do want to thank Castle Group for this opportunity. It's very helpful for us to hear the questions from you all and for you to hear our answers, and we can kind of work through the new laws together. So I appreciate the opportunity and do want to thank Castle. I'm Richard DeBost, Godin, Amzik, DeBost and Cross. We're a full service law firm, but a large primary area of our practice is representing community associations. That's all I've done for, I hate to say it, 28 years now. So I always learn something new, and let's get it rolling.
Let's go. Oh, quickly, this will not, for CAMs who are on, you will not get credit for this just yet. It's got to go through the governor's hands officially in October, and then Richard and I will meet again. And you'll be able to get credit at that point. Go ahead. Sorry, Richard.
Okay, that's okay. So a couple of things. Not all these bills have been signed by the governor. He has to the end of the month to sign them. So we're a little early. There is a small possibility he would veto one, but the word from Tallahassee that Laura is connected with, and I have some people that we all kind of have the same people we talk to. The word is these are not going to be vetoed or anything like that. So we do expect them to become law as of July 1. If perchance one of them gets vetoed, we will send out another update and indicate exactly what I'm just telling you now is not the law. But let's hope that doesn't happen. We're gonna cover the general community association laws for condos, HOAs, and co-ops and homeowner associations. And those statutes, when I say 617, that's the not-for-profit corporation statute. 718 is for condos. 719 is for cooperatives. 720 is for HOAs. There's a timeshare statute, 721. There's nothing we're going to cover there. And then there's some miscellaneous statutes that do affect you we're going to cover at the end. It was a very busy year in Tallahassee for several reasons. A lot of these new laws were proposed in 2020, but let me see. Something happened in 2020 that kind of derailed our lives. Oh yeah, COVID. So these laws did not get passed because the legislature stopped and started dealing with COVID. So some of these laws, were going to be passed last year, but they were passed this year. Some of these laws deal with COVID. So it's a pretty lengthy list. So it's going to take some time to get through this. Some of it's redundant. So they repeat the same law in each statute. So when we get to the redundant parts, I'm just going to skip through them because I don't need to repeat what it said. But with that, we're ready. The SB, if you want to look these up, the SB stands for Senate Bill. The HB stands for House Bill. You can go to My Florida Sunshine, go to the Florida Senate, put in SB and the number, or HB and the number, and you'll see the full text of these statutes. You won't find these statutes in the online statutes because they're still 2020. They're not 2021. They haven't been updated. So next slide. Okay. These next two I'll go through them very quick. What they basically did, 617 is the not-for-profit corporation statute that applies to almost all community associations. And sometimes those laws that also apply to other not-for-profit corporations like charities and all kinds of other things, sometimes they conflict with 718, 719, or 720. So these first two slides basically just say where they conflict with 617, your specific statute will control in the areas of quorum and meeting notices, et cetera. That's all that happened there. Okay, same thing. Okay, official records. Okay, this is condominium 718. Bids for work performed for materials, equipment, or services must be kept for at least a year. It used to say you had to keep the actual bid for 7 years. You don't have to keep the bid for 7 years. You only have to keep it for a year. They've, in number 2 here, the all other written records, which is the catch-all category, has been slightly revised to say all other written records which are related to the operation of the association. I guess this, I don't know what record you would have that isn't related to the operation, so I'm not sure what this really clarifies, but that's what they did there. They added that. The second part of that statute, and you're going to hear more about this later, there's a new document you're going to have to keep. And there's a funny story behind where this all came from, which we'll get to in a few slides. But there's a new document that if you change the method of delivering the invoice for assessments, let's say you mail all invoices and then you go to, we're only going to email. If you change the method that you've been using to deliver the invoices, you have to obtain, and don't ask me how you get this if they don't want to give it, you have to tell everybody, we've changed the method of delivering your invoice. And then you have to get from them an affirmative acknowledgement made pursuant to the statute, which basically says, oh, I got the notice. I'm aware that you changed the method. And then you have to keep that as an official record, but it becomes a protected official record so other people can't see it. And again, we'll get to the funny story behind it in a bit.
Right. So yes, and then an example of that, I believe, Richard, would be if someone opts into receiving electronic information, right, meeting notices. Now there's a form, correct me if I'm wrong, that they will need to sign, and the association will need to keep on record in case, so that it's not just a verbal walk-in and they say, yes, put me on the list. They're going to have to sign saying that they've acknowledged that they've agreed to that.
Exactly. This next one, number 3, 718, 111, 12C. A couple of years ago, for some reason, they said renters who do not have the right to look at condominium official records because they're not owners did have the right to look at the bylaws and the rules. Now, if you know anything about your condominium, there's declaration, articles, bylaws, rules. Why they said only the bylaws and rules, I don't know. Now they've expanded it in 2 ways. They've said they can look at the declaration in addition to the bylaws and rules. They're allowed to look at the declaration, and they've added the word only. So the only official records that a non-owner renter can demand to inspect and copy are basically the governing documents, which I guess makes sense since they have to follow them. I guess that makes some sense, but they can't come in and look at non-governing document official records.
Contracts of the association, et cetera.
The next one, you may recall, if you're a condominium with 150 or more units, as of January 1, 2019, you were required to have a website and post certain documents on the website. So now I guess they're looking towards new technology. This new law will provide that instead of having the website, you can have a downloadable app that I really don't know the difference of an app and a website, but
yeah, you would still have to have, if you have a mobile app, you would still have a portal, right, where that information is, which is typically a website.
Right. So the downloadable app you can use instead of the actual website, and it has to meet all the same requirements of the website and be password protected and et cetera, et cetera. So that's that. The next one, this is just if your governing documents are really old and they might contain illegal discriminatory language based on the protected classes of race, creed, color, age might typically be in there. You don't have to get the owner's permission to amend the documents. You can remove that antiquated language if it otherwise violates federal fair housing law by discriminatory language. So it's just an easier way to clean up your documents. If you do have that language in older documents, and I have some from the 60s and earlier that have language about certain types of classes of people can't live here, or certain aged people or something like, and associations will leave that in there. So, well, we don't enforce it, but we just left it. Since you can't enforce it, get it out of there, because it's just going to lead to problems later when somebody sees that language and thinks that you are enforcing it. So I would definitely ask your attorney about that.
Okay, I did have a question come in on this topic. So if someone 30 years old inherits a condo in a 55 and over development, what are the association's legal rights in that situation?
If they're a properly established 55 and over housing for older persons community, and they administer, I'm getting a little technical here, but you have to have 80% of the homes occupied by one person 55 or over, and then 20% can be up to what the board wants. So it really depends on what that particular community is doing. If they use that 20% to allow non-55-year-old people to live there, then he could live there or she could live there. But most 55 and over communities, in my experience, do not use that 20% except in an extreme hardship case. And if it's properly operated, they could tell the 30-year-old, congratulations, you can own your home, you can rent your home to someone 55 or over, but you can't live in your home until you're 55. They could do that. That's legal if they're administering their 55 and over status properly.
Great, thank you.
This next one is finally since 2018 in condos only, we've had this 8-year continuous term limit law that says you can't serve more than 8 continuous years, and then you're termed out and you can't serve again on your condo board unless you meet certain other criteria. There was confusion about when does the 8 years start to run? Does your service prior to July 1 count in the 8 years, or is it only the service from July 1 forward? Well, after all kinds of back and forth and up and down and confusion, they finally, it is dispositively, you only count July 1 forward. So until at least July 1, 2026, nobody needs to worry about this law. And let's knock on wood, maybe they get rid of this law by then, because I think it's kind of silly. But that's
Well, because you can only get so many volunteers sometimes. And then you have people that sit on the board because no one else steps up.
Plus, notice the word continuous years. So it doesn't take a clever lawyer to say, okay, I'm going to serve for 7 years and 9 months. And then 3 months before the next election, I'm going to resign. And then when they send out the 60-day notice for candidates, I will put my name in. And I've not served 8 continuous years. I guess I start over. So it's just stupid. That's
I like you, Richard. Tell it how it is. Yep.
It's stupid. Okay, this one is interesting. 718-112. In the past, if you were going to run for the board on the day you turn your name in to be a candidate, if you were any number of days delinquent on the payment of any monetary amount owed to the association, that could be a key fob deposit, an assessment, that could be any monetary amount. So anything you owed the association, it's not current on that day, your name's not on the ballot. Now they've narrowed that down. It now says only if you are delinquent in the payment of any assessment on. So you could be late on a fine, you could be late on, I guess, interest and late fees and things like that. But if you're still eligible to serve on to run for the board. If you're delinquent in the payment of an assessment, you're not. Now, keep in mind, they did not change the law, that the other part of the law that says once you're on your board, if you go more than 90 days of any monetary amount, so that monetary amount category still exists once you're on the board, then you can get removed from the board if you're more than 90 days delinquent. When you're running for the board, there's no 90-day rule, and it's just assessments now. That'd be regular or special assessments.
So that would be a time where the manager and or whomever could notify anybody who's putting their name in the hat to be on the board. Here's what your account balance is. You owe a $25 late fee from 2 years ago you never paid. And
right.
Should you get elected, you need to go ahead and come current.
Yeah, I think where this law came from was there have been a lot of shenanigans in other condominiums, particularly maybe in the Miami area, that I've heard stories where there's a clique of owners that own a lot of units and they want to control the board. And so when they control the board, they put falsified charges on people's accounts and then say, sorry, you can't run for the board. And then, there was abuse going on. And I think this could help curb that. The next one here, where are we? Number delinquent candidate eligibility. Okay, next slide. Notice of members meetings. Okay. I guess it's been clarified now that all types of members meetings, special and regular, have to have 14 days mailed and posted notice. The prior statute, I think, allowed your bylaws to say something different for special members meetings, not regular meetings. Also, they've clarified that you can post the notice on the condominium property or association property. And legally, those are two different things, which I don't need to get into. But anything that's part of the condo now, you can post that. That's where you can post the notice. And typically it's at the pool or at the elevators or something like that.
I do have a question. So if you're a condo and you have a website, are you required to send an email to owners when the notice of the meeting? If you post the notice on the website as well, or as long as it's posted on the website, you don't have to send an email?
I don't think you ever have to send an email. I'm thinking a lot of places post it and then as a courtesy send an email.
Yeah.
And remember, electronic notice is only the, normal board meetings don't require sending anything anywhere. It's posting only. So you never have to send a 48-hour posted notice board meeting electronically. You would if it's a special board meeting or a members meeting where you have to mail and post. So in lieu of mailing, you could email if that's their preferred choice.
Yeah, it's a courtesy and transparency.
Right.
It helps with. Yep.
Okay. Okay. Number 9, the board shall adopt an annual budget. This basically says if you have to adopt your annual budget at least 14 days before the next fiscal year. That's now a law. If you fail to adopt the budget, and I think it's a second time failing to adopt the budget, you can get a minor violation from the division, which could mean a fine from the division. So the next one, number 10, this is in condo only. Okay, there's it's not in HOAs, and it's in, I think it's in the co-op. I don't think they changed the co-op law. This is the transfer fee that you're entitled to get if your documents in your condominium allow you to approve or disapprove sales or leases, called collectively a transfer, and your documents allow for a fee. The fee by law was capped at $100 per adult applicant, with spouses considered a single applicant. They've now raised the dollar figure to $150 per applicant, with spouses still being a single applicant, and they've added a consumer price index increase. So theoretically, in 5 years, the figure might be $155.34, depending on what the consumer price index does. But for now, you can charge $150 instead of just $100.
And Richard, a question on that was, do the associations need to update their documents to reference the increase in transfer fee?
That is a great question, and it depends on your documents. Some documents will contain what we in the business call Kaufman language, which says something like the transfer fee is $100 unless otherwise provided by law, or it might say the transfer fee is the maximum amount allowed by law as amended from time to time. If it's a set fee and doesn't say according to law as amended from time to time or similar language, you're stuck with what your document says, and you would have to amend the document to change that dollar figure. If your dollar figure says it's $100 unless the law changes and then you can charge more, that's what it legally would say, something to that effect, then you would not have to. So you're going to need to ask your legal counsel, but that's a great question to see.
Recalls.
Yeah, recalls. What they've basically done is, instead of, you have an option now when you go to you recall your board of directors. If the board rejected the recall in the past, you had to go through what's called recall arbitration through the Division of Condominiums. You now have a choice. You can go through recall arbitration, or you can go straight to court. Okay, so your lawyer would advise you which is the better route. You can go straight to local court, or you can go through recall arbitration. And they've done that in a lot of sections you'll see coming up. The next one is 718 used to contain 2 parts of the statute that talked about director conflicts of interest. And they were kind of confusing because they weren't exactly the same. So from my understanding here, they've removed this one and they're relying on the other one only. So you don't have the same subject covered twice, which led to confusion. So this is just kind of a cleanup. We call it a glitch bill. The next one is interesting. And again, sign of the times. Apparently the next big thing, and I'm not even caught up to the new big thing now, which is electric vehicles. I'm still a dinosaur. But the next big thing is natural gas vehicles. So what they've done here are 2 things. One, they've basically taken the existing electronic charging station statute, which allows an individual owner to install at his or her cost an electrical vehicle charging station in their limited common element parking spot. Okay, they can't just go run out and do it in the guest parking. We'll get to that in a minute. Now they've taken that same law and just simply said it's also going to apply to natural gas charging stations. So it's basically the same law, but you choose which one your vehicle is going to use. I guess that's a good thing. Whether it's advisable to put a natural gas charging station next to an electrical vehicle charging station, I don't know. I guess engineers would tell you that. The next one is a good law. This is another natural width. Now this applies to both. When they adopted the electrical vehicle charging station law, the question then arose, well, what if the association wants to put in as a common amenity electrical vehicle charging stations? And we said, well, that would be a material alteration. Depending on your documents, you're going to have to get a vote of the owners to do it. You're going to have to make it a common expense, et cetera, et cetera, et cetera. So it could be done, but you just had to jump through some hoops. Now, this new law says that the board, without a vote of the owners, can install common element for the general use of all the people in the condo, electrical vehicle and gas vehicle charging stations, and it will be a common expense. And then they can add on other ways that people would pay, et cetera, et cetera. So the good news is if you want to be forward thinking and improve your common elements with this type of equipment, your board can do it without a unit owner vote anymore. Okay. Now the next one here. In the past, in an HOA statute 720, you had to send delinquency notices to owners and intent to foreclose notices of your assessment lien 45 days ahead, but condo always said just 30 days. So there was almost the identical laws, but condos, the time frame was only 30 days, HOAs was 45. What they've done is they now made condos the same as HOAs and co-ops. Everything's 45 days for the intent to lien letter and the intent to foreclose letter.
Go ahead.
Go ahead.
I think I had a question. I'll get you at the end.
Okay.
I'll find it. All right.
Right to contest termination of your condominium. This isn't going to come up hardly ever. It's a pretty rare event. But if you did, you have the option to go to court or go to arbitration. You don't have to go only to arbitration. If you say they terminated the condo improperly, which means did away with the condo and tried to sell the land, more or less. The next one, if an owner installs that electrical vehicle charging station or natural gas charging station and they don't pay their contractor, this makes it clear that the contractor cannot lien the common elements. They can lien the unit for a construction lien, but they can't drag the association into it and tie up their stuff because the owner didn't pay his contractor. That's all that does. Okay. This is the one where the funny story exists. And you're going to see this law in 719 and 720. So I won't go through it 3 times, but here is the story that I've heard without naming any names. Apparently there was a high-ranking member of the Florida Senate that owned a condo. And I think 2 things happened. They changed the method of sending invoices to this person. And as a result, this person didn't get the invoice, didn't pay the assessment, and it went to collections. And now I know in my business, when I see someone that, better maybe give them a courtesy call first. Sometimes you don't just run it through the normal system. And I'm not saying treat anybody differently, but hey, public figures, oftentimes you might say, hey, you probably overlooked this because you're busy and maybe you want to pay it. Well, this didn't happen. And apparently there was a collection started against this person, and this person got upset. And so he changed the law. And he's now imposed, he or she, I'm not going to name who it is, the new law, and it's not a bad law. It's just, that's where it came from kind of getting on the wrong, poking the bear a little bit, I guess you could call it. So number 1, we've already talked about it. You have to give 30 days notice before you can change the method of delivery of the assessment invoice, and you have to get a written acknowledgement back that they did it. But the other thing that they've done, and this is going to affect Laura's business and my business and your operation of your association, and again, this is in all 3 statutes. You now have to give another notice before the 45-day letter of intent to lien and the 45-day letter of intent to foreclose the lien. You now have another letter that has to go before those letters, and I'm going to call it a 30-day courtesy reminder. Now, most associations, and I know Laura probably familiar with this, you already kind of do that. You have like a 10-day grace period, and then most associations just on their own send out what I call a friendly reminder that says, hey, you might have overlooked this, please pay. And sometimes there's a little money tacked on, sometimes there's nothing, but it's a good way to get paid without having to go up the chain and incur a lot of legal fees. Now, by law, that courtesy reminder has to be sent to the person 30 days before it goes to, before any legal fees can get tacked on. So before you can send it to the attorney and incur legal fees and then recover those legal fees from the delinquent person, you're going to have to send this 30-day courtesy reminder with no legal fees on it. So our office is got a new item on the checklist. When we get a collection account, we're going to say, where's that letter? Because without that letter, we can't charge attorney's fees and you won't recover attorney's fees, and it delays things. The other fun part of this is the person sending that letter, that 30-day courtesy reminder, which presumably is your management company or maybe your board member, has to fill, if they fill out an affidavit that says, I swear and affirm I emailed or I mailed or whatever way you delivered it to this person at this address, that creates a rebuttable presumption. So when the person says, well, I didn't get it, they got to prove, it doesn't matter they didn't get it. If you can say you mailed it to the right place with the address that they had provided to you, that's going to be good. So there's another piece of paper now. You're going to have to fill out an affidavit so that it creates that rebuttable presumption. But this is in all three statutes, like I said. Okay.
What's that?
Yeah.
Again, going through the statutes.
Right. I think we're on the next one too. Okay.
Turn to dispute.
Again, mandatory non-binding arbitration in condominiums, which was mandatory for years and years and years now, is now no longer mandatory. It is, you can, to go through a condo dispute, like your dog is overweight, get the dog out, and the association wants to enforce the rule and they can't enforce it because, nobody pays the fine or anything like that. You would go to mandatory non-binding arbitration, which is through the division, which is like a trial, and they determine a winner or a loser, et cetera. Now you have the option of going to mandatory non-binding arbitration or non-mandatory arbitration, or going straight to court. Again, talk to your legal counsel about which is the most efficient and way to do that. But you have more choices now, so that's good. Okay, this is one I worked on this statute, and again, you're going to see this statute, basically the emergency power statute in condos, HOAs, and cooperatives, 7, 18, 19, and 20, have a very similar statute, okay? This arose out of COVID because the emergency power statutes have been around for, 10, 15 years, which says in an emergency, the board has certain extra special powers that they can do to keep people out of the condominium or off the HOA property because it's unsafe. This was all presumed on more or less a hurricane or a fire or some kind of natural disaster that made the property physically unsound. That was why those emergency powers were put in place. So back in March of 2020, when COVID hit, we all thought, well, it's a state of emergency declared by the governor. Do these emergency powers apply? And there was a big debate that yes, they do, or no, they don't. And the drafters of this law admitted we never contemplated a pandemic for this. So it really doesn't apply. That wasn't what we intended, but we used them anyway. And we felt like we were on pretty good ground to use them, but it caused some problems. So I was on a task force committee to help rewrite the emergency power statutes. And our committee, I thought, did a pretty good job. And then when the politicians got it and the other interest groups got it, they pretty much ripped apart all our work that took us a long time to do. They didn't throw it all out, but what comes out the other end in his law is not what we had done. We focused it more on association authority. What this has done now is, number one, God forbid we have to go through this again. The statutes are now clear. They will apply to health pandemics, okay? So there will be no debate. That's a good thing. That if nothing else happened, that was our primary goal, was to make that clear. So now it is clear. Where it kind of got derailed a little bit, and this is just my opinion, there are other lobbying groups that had other interests that are legitimate as well. Well, primarily, the way I look at it, the real estate lobbying groups, they were upset primarily when boards like yours, and I imagine you did this, limited access to the property. Either you can't hold open houses, you can't show the unit, you can't continue your renovation project. And in some cases, they even said, you may own that unit, but you're from New York or New Jersey, and we're not even letting you come live in your own unit, okay? That was frequently done, particularly in the early days of the pandemic, okay? And that's because the statute, even though it wasn't intended for pandemics, clearly said you could do that. You can restrict access. Well, now you will be able to restrict access, except you can't restrict ingress or egress, which is coming or going, when the access is necessary in connection with A, the sale, lease, or transfer of title to the unit, which means you can't prevent the real estate people from coming and showing and walkthroughs and holding open houses. You can't do that. And if the unit it's necessary to get to the unit for the habitability of the unit or the health and safety of such persons, unless a government order directly says you can't. That's the convoluted way of saying, I think it means if an owner shows up and says, I don't have anywhere else to live, you can't say you can't come there like we did. So those are the two big things that they did to make it clear. But again, it's in all three statutes now.
Now, hey, Richard, a question. So let's look at COVID-19 with this emergency power, assuming this all goes through in October. Would you be able to require the owner to stay in their home for 14 days, according to the CDC record? Like, we can let you back, but now we're going to make you stay in your unit. If the CDC says you have to quarantine for.
Yeah, if the government, yes, if the government, CDC and with authority said, if you have COVID, you can't leave, which essentially is what they did. I think you would be able to do that potentially. Yeah. Hopefully none of this is going to be necessary.
I know. I hope it never comes back, but I could see it saying, okay, we let them come back, but now we're going to make them stay. And then the owners are mad because they can't go to the grocery store.
But you would still be able to limit access to like the amenities, like the pool, the club. But coming and going is going to be not
their own unit. Yeah.
Which, you know, makes some sense, I guess.
Yes, it does. Yep.
This next one is just we can go on to the next one. The developer powers, developer pre-sales deposit. This is just an expansion of the developer's right when their developer is building a condominium. In the past, they could use the pre-sale deposits that people put down for only the actual construction of the project. Now they've expanded it so the developer can use that money for other things related to the project. So unless you're a developer, not really something you need to worry about.
But so let me ask you this, but as a association that's turned over, this is only for condo? Yeah, 718. Is this going to go to 720 as well?
No, there's no similar law in 720 on this.
Okay. All right. So, all right.
Okay. The next one is fines and suspensions. This is a good thing. A couple of years ago, they tweaked the law for fines and suspensions that said, once the committee approves the fine is due 5 days after the meeting. Okay. So they approve the fine. The committee says, yes, you're fined or you're suspended. And then the law said, you got to pay the fine within 5 days of the meeting date. Well, that was impractical because you haven't even got around to telling the person. They might not have attended. You haven't sent them a letter saying the fine is valid. You got to pay it. So it was just too short of a time frame. So now they've changed it to say the fine is due 5 days after you send them the notice. So you don't have to send them the letter the next day. It just gives you more time and more opportunity to pay. This is just a technical thing. If you have several condominiums that have like villas 1, 2, and 3, and they're virtually identical documents, just a different name, a different Roman numeral. In past, it was a common practice. I did it all the time. I do it all the time. You would want to amend and restate those documents, but instead of having 3 separate declarations, you would combine the declarations into a single declaration and say, this is the declaration for Villas 1, Villas 2, and Villas 3. And then it would only be different where maybe Villas 1 had 20 units and Villas 2 had 30 units. You would distinguish that in the documents. And it just made it easier. It did not merge the condominiums. It did not make you one condominium. It just put the 3 documents that were identical anyway into a single document for ease of use. We call it amending, restating, and combining. Well, there was a little question out there. Well, can you really do this? And a lot of people did it. All this does now is say, yeah, it's legal to do that. So we're all good.
Oops, sorry.
Okay. Okay. This just says the Division of Condominiums can, its authority to cite the developer for doing bad things has expanded. It's a little bit bigger than it was. They can investigate financial issues, elections, and official records. And yeah, they've added a bigger category, so you can complain. Now, this next one, this is probably the most important change in the law. I want you to pay real close attention. The Condominium Ombudsman's Office is now no longer required to be located in Leon County. I mean, that we've been waiting for that for years. Of course, I'm being facetious. I didn't even know it had to be recorded. We're there. I'm sure the ombudsman is happy because I don't believe he lives in Leon County. So, you know, I'm just making a joke out of it. But
Yeah, why do you think that was? I didn't know about it either.
I don't know.
Yeah.
Okay. Now we're on to cooperatives. A lot of everything in here is identical. So I'm not going to go through it. I'm going to scan through it on my side. And I think we can pretty much, it's the same stuff that I just talked about, but it's just in 719. Virtual board meetings, you've now cleared up that you can do that. Oh, also in the emergency powers thing, they've cleared up. Oh, I forgot. For the emergency powers, they also have made it in the statutes, all 3 of them, that you can hold virtual board meetings and membership meetings and hold virtual election meetings in condos, co-ops, and HOAs. That was another big, well, we're not sure because the law said you had to be at the meeting instead, et cetera. So in emergency powers, that's helpful.
Listen, so I'm on 719 annual budget. This is all the same.
It's all the same. Courtesy notice, 30 days and all of that is the same. The emergency powers are the same. So now we're to homeowners associations, and there are some differences here. The first one, a couple of years ago, they expanded the definition of governing documents to include board adopted rules. Okay, that sounds reasonable, right? Well, they forgot that another part of the statute says that any amendments to the governing documents must be recorded in the public record. Therefore, because governing documents now include board rules, amendments to board rules have to be recorded. And not a lot of people like that because boards come and go. They forget to record. They record the old rule, and it just creates a mess because they're not consistent. And board adopted rules tend to change with every board. Okay. So I think they've tried to fix a problem, but done it in the wrong way. First of all, the way they fixed it is they said the term governing documents does not include board adopted rules anymore. There go, you don't have to record amendments to them. Well, I don't know. I think it's good to say that the board rules are governing documents because in my opinion, they clearly are. So how, you know, if you say something like all owners have to follow the governing documents, people will say, well, the definition of governing documents doesn't include rules. I mean, that's an argument they could make. I don't think they should have done it this way. I think they should just say, except you don't have to record board adopted rules. I mean, why not? But this is the way it is. The next one is again, kind of, I don't know, did we really need this law? It says, in addition to the required method of sending notices of meetings, the board can also adopt a procedure to send you a courtesy electronic version. They still have to do the old way, but they could send you a courtesy electronic version. Well, you could do that anyway. There's no law that says as a courtesy, I can't send. So I don't really know what this accomplished. Again, somebody may have more input on this later. We'll find out what it was really meant to do, but you can read it for yourself. You can't do it in lieu of, though, unless that's how they've chosen to receive it. Okay, the next one is official records. This is a change in the HOA law to make it consistent with the condo law, which says election ballots, sign-in sheets, and voting proxies and other records related to an election or a voting by the owners only have to be kept for a year. And Condo Act has always said that. The HOA law didn't mention it, so now they're the same. Election material only has to be kept for a year. The next one is this same thing with the change in the 30-day courtesy notice and the change of delivering invoices. That has been put into HOA law. And again, you have to keep it as an official record. Let's see.
I may have jumped ahead of you too far. Are you on HOA reserves, the year end?
No, yeah, go back. I'm on, oh yeah, this is that one. Okay. Another one, and this is 72303-4I3. I think it's the next slide.
Yep.
Yeah. Okay. This says that at a gated community, the guest list visit log is an official record, but it's a protected official record. So owners can't come and say, show me the gate log for my neighbor. Now, what's interesting to me here is you do not find this same law in 718. And there are plenty of condos that have a gate, right? And it's not just gated HOAs that have this. So in a condo, if you had a gate log, or I guess a front desk log, you would still be able to get it. But in an HOA, it's not an official record you're entitled to see.
Interesting.
Yeah. Okay, the next one is HOA reserves and year-end financial. If the HOA does not maintain statutory reserves, which means mandatory restricted reserves like a condo, or the governing documents don't obligate the developer to create the reserves, this has to be noted on the year-end financial report, which effectively there's already a disclaimer you put on there when you don't fully fund HOA reserves because you don't have to or you've chosen not to. This is just added to that. Your CPA and your person that prepares your year-end financial report can, comply with this for you. The next one is a let's help developer law. And I'm not against developers. They make nice communities. We all like to live in them, but I'm often, I think it's go back one, Laura. There you go.
The statutory reserves. Oh, sorry about that.
In the past, statutory reserves, which means reserves controlled by Statute 720. That's what we mean by we say statutory reserves. And once you create a statutory reserve, you have to fund it every year and only use it for the purpose intended unless the owners vote to waive or reduce funding or use for another purpose. Okay. If they're non-statutory board adopted reserves, they could do anything they want with them. There's no control. It's non-statutory. What this has done is in the past, statutory reserves were created in one of three ways. The developer created it voluntarily in his budget. The governing documents required it, or the membership voted to do it. And I think the impetus behind, now they've removed category one. The developer that voluntarily establishes reserves in his budget before turnover does not create a statutory reserve and doesn't have to fund it the next year if he doesn't want to. This helps developers because oftentimes after turnover, the board would look at the reserves and said, well, you started putting money in a roof reserve, but you gave the roof a 90-year life, which is totally not right. Therefore, you underfunded the roof reserve. It should have been a 30-year life. And during your period of stewardship, you should have put more money into it. And the developer would get caught because it's a statutory reserve that says you can't waive it without an owner vote. So I think this is to help developers to say, unless I bind myself in my own documents to mandate this reserve, if I happen to make a developer budget with a reserve item, you can't hold me to anything that's not enough in it, didn't fund it right, anything like that. That's why it helps developers. The next statute kind of goes along with the same thing, so I'm not going to go through it very much. You can read that if you still have a developer issue. The next one, recalls and fines. Those are exactly like the condo law that we talked about. You can go to mediation or arbitration, and then the 5-day business with the fines is 5 days after the notice. The next one is called notice of amendments. I think we're on.
Yep. And I'll
Yeah.
send, Richard, are you good with us sending copies of this out in a
Yes.
PDF? Yeah.
Yes.
So
Yes.
I'll send a copy out to everybody who's registered here.
Right. This was a silly law from a couple years ago that said when the HOA amended their governing documents, they have to send notice to everybody that says, hey, that amendment you voted on last week, we recorded it in the public record. I guess that's not a bad idea, right? But they said you had to send it to the address listed on the property appraiser's website, not necessarily the address that you have in your list for your owners who said, mail my stuff here. So nobody did it. Everybody blew this off. Nobody did it. And when they did do it, they didn't go to the property appraiser's website to look everybody up. They simply used their, residence list. Now the law just says you can use the mailing list that you have. So if you are going to do this, which you're supposed to, there's no penalty for not doing it. When you amend the documents, you're supposed to send a notice to everybody that says, hey, we amended the document and it's been recorded. Okay, the next one. This is the most significant change for HOAs. I'm going to take a little time to explain it because there's some timing issues that are very near July 1 as when this becomes law, assuming this bill gets signed. This is part of the big, what they call omnibus condo bill, which is the big bill that most of the condo stuff was in. So the odds of the governor signing this are almost 99.99%. If he hasn't, I didn't check today, he hasn't signed it already. What they attempted to do here, and they've tried this for years, is number one, 718, the Condo Act, for many years has contained a restriction, a grandfathering clause that says if you restrict the number of times you can rent during a year, or you change the minimum or maximum term of a lease that you can rent your condo, let's say it says 3 times a year, no less than 30 days, and you want to change your condo declaration by a vote of the owners to say, no, we want to make the minimum lease term 6 months and only 2 times a year. That there's a law that's been around 15 years now, I think, that says anybody who doesn't vote for that amendment or anybody who didn't vote at all for that amendment, if you voted no or you don't vote at all, you're grandfathered, and that change does not apply to your unit until your unit is sold to a new person after the date of the amendment is recorded. So you have 2 tiers of people, those that are under the old rental rule and those that are under the new rental rule. And it's been around for years and we've all lived with it, and okay. So the concept is not crazy and it's not foreign to us. Well, why they didn't simply take that same language and put it into 720, because that's what they were attempting to do here. Let's make HOA rental restrictions the same kind of grandfathering thing. So why they didn't take the same language and do it, I don't know. What they've done here are 2 things. Number one, what they've said is, if you don't vote for it, here's what they did. The amendment, it's any amendment that, and I'm quoting from the statute, prohibits or regulates rentals. That's the phrase in the statute. Any amendment that prohibits or regulates rentals, if you don't vote for that amendment or you vote no on that amendment will not apply to you. It'll only apply to those who voted yes and people who buy after the date of the amendment. Well, think about it. Any restriction that prohibits or regulates rentals, that is extremely broad. I mean, that is a barn door. You could say, owners can have pets, but renters can't. That's a common amendment. Well, does that regulate my rental? Arguably it does, right? I can't rent to someone with a pet. Now, we won't go into the emotional support animal and all that, but that's an example of where this broad language, in my opinion, is going to create a lot of arguments as to what actually regulates. So that's problem number one. And if you want to get in underneath this date, you got to record this amendment by July 1. If you record an amendment regulating your HOA rental restrictions and get it recorded before July 1, you won't have the grandfathering issue because that law doesn't occur until July 1. So you got about 3-4 weeks to scramble. And I know I got some associations that are scrambling to get in an amendment like that. That's number one. So I think it's going to create some difficulty. Now, the other part of the law says, regardless of what I just told you, you can still, and this is basically directly applied because of Airbnb. The second part of the law still says, regardless of the foregoing, if an association amends its governing documents to prohibit or regulate rental agreements for a rental term of less than 6 months and for less than no more than 3 times a year, that amendment does apply to everybody. That's effectively, you will still be able to globally stop Airbnb short-term rentals, and they will apply to everybody. But any other amendment that regulates or restricts rentals, which I presume could be you impose the right to approve or disapprove rentals, that regulates rentals. So you're going to have, this is going to become very sticky, and you're going to need to talk to your legal counsel about this before doing anything on it. Okay, the next one is election disputes. I think we can go past these 2 slides. Yeah, this is the same thing. You can go to court or to the DBPR for an election dispute. You don't have to go to pre-suit mediation for an election dispute. The next one is this whole courtesy late notice, change of method of delivering business that we talked about. The next one is you can remove the discriminatory language from your, I think we're one more, yeah, you can remove the discriminatory language that we talked about. The next one is the emergency powers law for HOAs, which is a slightly different law because HOAs, you know, they're typically single family homes that aren't attached, but it's those big changes are in that law too. So we're doing pretty good here, Laura.
No, we're doing good. Then we can rattle through questions.
Yeah, I think I got about 15 minutes or less on this, and then we'll be done. So timeshares, there were nothing. Mobile home parks, I mean, there may be some that I'm not aware of, but I didn't find any. Mobile home parks, there's no changes. Now the next one, these miscellaneous ones, there's some significant changes in here. First of all, condominium insurance subrogation. It now provides, if the condominium association's insurance policy does not provide rights for subrogation against the unit owners, which means if the association's insurance company has to pay out a claim, they can step into the shoes of the association and sue the owner and said, because of your negligence, you caused us to have to pay out a claim for the association. That's what subrogation is. It now provides that if the association's policy, and it works both ways, when a unit owner's insurance policy provides for subrogation, when they have to pay out a claim, they can sue the association and say, you did something wrong, association, and now my insured got harmed and I had to pay his claim. I want you to pay me what I paid him. That's subrogation. It works both ways. It now says if the association's insurance policy does not allow subrogation, then the individual unit owner can't allow subrogation either. It's supposed to cut down on what some of us perceive as frivolous water leak claims where certain insurance companies and law firms, if there was a water leak from outside to inside, no matter who caused it or if it was caused by a meteor, they would sue you and say the association was negligent. So it's supposed to curtail that bit of industry there. Okay, this next one is a biggie. Okay, when COVID hit, the first thing we all started thinking about for clients and management companies and other businesses was this is going to create an industry of lawyers, love them or hate them, that are going to start suing anybody with an insurance policy because they're going to claim they got COVID at your pool or your clubhouse or whatever. So it was, you know, everybody was freaking out about liability. Very quickly, the insurance company said, oh, no. You're not covered for any of this. You never have been. You never will be. So when you get sued, don't come looking for insurance coverage because you're not going to get it. So that made associations and other businesses and things even more freaked out, like, oh my God. Okay. Well, this now says, you know what? I'm talking about the wrong law. But I'm telling you, we're going to see in the next slide, but I'll finish that. I'll finish what I'm talking about. That's the COVID immunity statute. It's several down, but it's in there.
Okay.
The COVID immunity statute basically says, if you've taken reasonable precautions, the CDC guidelines, and you did all those normal things that everybody was doing, closed the gym, limited capacity, wiped it down, required masks. If you did all that, then you are basically immune from liability for COVID claims unless the person making the claim, and I'm not going to get into all the details, can basically prove a lot of really, really hard things to prove. So it should go a long, long way from preventing, let's just sue the association and see how much insurance money or any money that they'll throw at us, because it's going to make it very difficult for them to pin liability on your association as long as you took those normal precautions. So that's the law later on down. The law we're looking at right now is also one that has been kind of debated a little bit. This is the one that first it was an executive order from Governor DeSantis, and then they turned it into a law. Okay, and it's, can businesses provide, or can businesses require patrons and what do they use? They use customers and patrons. Can they be required to prove they have COVID vaccines, like a vaccination card, before you can eat at McDonald's or something, or whatever it might be? This law basically says you can't do that. Okay, you cannot require proof of COVID vaccination for businesses. Now, where this has become a little bit debated for community associations is are you a business? Well, you fall under 617, the not-for-profit business statute, so seems like you are. On the other hand, the law specifically says you can't require your patrons or your customers to provide proof of vaccination. Well, what are your owners and renters? Are they patrons or customers? I don't know, Bottom line is this. We're recommending that you follow this law, because you don't want to be the test case to find out, because the penalties are $5,000 and up, if you get caught violating it. So you don't want to be the test case. Secondarily, there's a question about violating fair housing laws if you try to deny people access or rentals or occupancy based on they didn't have a COVID vaccine. There might be a religious protected class reason not to get it. There might be a handicap protected class reason not to get it. Let's not talk about our own free will, but that's for us to talk about in private. So we're recommending you're not trying to provide proof of COVID vaccine. The question came up the other day, what about our employees? You can require your employees, your literal employees, to have COVID vaccinations. It's very technical, and you definitely want to go see an employment law attorney if you're going to impose it as a requirement for work, because it's a minefield of doing it wrong. So you could do that, but for your owners, our position is you cannot require them to prove they have a vaccination to use the clubhouse or to go to their wherever. The next one is what I've already explained, the liability protection law. So we got past that. The next one is the association. I think it had this before, but associations now have, I think it's for condominiums and co-ops and mobile homes only. It's not for HOAs. Your association as a group can challenge the ad valorem tax valuation given to the units as a group. I think you could do it before because it says restores, and then they took that away, and now they can do it again. So instead of your individual homeowners going and having to do it in, remember, condo co-op or mobile home park, the board could do it on behalf of everyone. That's essentially what this does. This next one is a good law that I have personally dealt with, and it's very frustrating. It was, because it's literally no difference. For years and years and years, if you're a condominium and you had 32 units or less, basically a small condominium, there were certain parts of the health code for pools that apply to public pools you didn't have to comply with. Number one, I think the big one was oftentimes you didn't have bathing or bathroom facilities next to the pool. So if you were 32 or less, you didn't have to have that. And a lot of old condos didn't. And if you were 33 units or more, you did, and you might have to retrofit and build a bathroom. And it was, it was just an exception for small condos. The odd thing is that that exception did not apply to small HOAs. So if you could be a small HOA with 4 homes and a common area pool, and you might have to build a bathroom. Okay. And I had one association that got caught stuck. They just closed the pool for years because they couldn't get the money to do it. Now, if you're a small HOA of 32 or less units, you do fall into the exception, except for certain things. And I know I have one client that's very happy about this law because they can open their pool again. These next ones are a lot. I'm not going to go through them in detail, but and some of it won't really apply to your association directly. These apply more to the individual homeowners. These laws came about because I think, perceived and real abuse that started occurring as we ran down the clock from when you could file an IRMA claim. That was 2017. You had 3 years to file a claim, which was, September 2020. And if you'll recall, not too long, into 2020 or before, you started hearing radio ads. Hey, let us look at your roof. We'll get you paid. Essentially, roofers, to some degree, and unscrupulous lawyers just promoting people making claims because they could shake down the insurance company when the insurance company said, hey, there's nothing wrong with the roof. You're 3 years later, you're telling me your roof was bad because of IRMA. And there was definitely some abuse. Most of these laws are designed to prohibit the solicitation and payment of owners by contractors to say, look, if you let me make your claim for you, I'll pay you $100 or something. So you can read through them yourselves, but they were primarily designed to prohibit bad practices in soliciting insurance claims. The next one is actual cash value coverage and replacement value coverage. I don't think this applies to the condominium or particularly condominiums and cooperatives that have to insure the common elements. The law already says you have to insure it for the maximum replacement value. So this is mostly going to apply, in my opinion, to the individual homeowner's insurance, where you can be offered actual cash value coverage or replacement value coverage. And there's a big difference. Think of it like this. When you wreck your car that's 3 years old, if you've ever done that, they don't give you enough money to buy and replace that car brand new. They give you, well, what is a 3-year-old car of this type and model worth? That's what we're going to give you. Okay. So you got the depreciated value more or less. That's what actual cash value versus replacement value coverage is. For example, your home roof, what this basically says is if they're going to offer you actual cash value coverage, which means your roof's 10 years old, it had a 20-year lifespan, it gets wrecked in IRMA, you're not going to get the money to put on a brand new roof. You're going to get the value of a 10-year-old roof. So you're going to be left short. That's what actual cash value is. Now, what does that do for you? Your premiums are lower, obviously. But when you need that insurance, you're not going to have all the money. Replacement value is just what it says. You're going to get enough money to replace it in 2020, brand new. If they're going to offer you actual cash value, they now have to put this big, bold disclaimer in there so you are dang well aware that you're not getting full replacement value. Again, I don't think this applies to condominium insurance. I don't mean condominium unit owner insurance. I mean condominium association insurance, because the statute says by law, you have to have replacement value for the clubhouse and for the condo roof and walls and things like that. The next two sections, you can read them. The big thing this insurance claims timing does is formally, you had 3 years after the date of the loss, which, for example, IRMA was September 10th, 2017, right? You had 3 years from that date to make an IRMA claim, okay? Whether it's your individual home or your condo association made the claim or whatever. Now, that date is 2 years. So the next time we have one of these, or even if you have a personal loss, you got a year less to do it. So you're going to need to be careful. Keep an eye on that. There's a couple other things it's done. I'm not going to go through it. The final one in this area is attorney's fees, which they basically put some limits on how much attorney's fees can be awarded to the insured's attorney that makes a claim. If you don't win a certain amount of money, you're not going to get your full fees. This was all designed to kind of tamp down the insurance abuse IRMA claim business that was happening. So again, maybe a fair balance between some of the bad, unscrupulous actors and the insurance companies. Bottom line is, and I know, Laura, you can talk to this, I mean, insurance premiums have gone through the roof, no pun intended. And so a lot of it's because they're tired of getting sued and things like that. So that's kind of 2021. I think we're at the end here, and I can take some questions.
I do have a bunch of questions. All right, I'll go over some of these have to do with some new laws and some are just some good information that maybe we need to have, maybe you have the answer to. So first, what is the status of providing visually impaired people rental information or they can have access to?
Okay, I think what the person is talking about is there was another little cottage industry that from time to time we would get complaints where the association was on their website allowing homeowners to list their property for sale or lease. Okay, that I don't think that was an uncommon practice. The theory from the lawyers on the other side that represented people of protected classes, i.e. a handicapped person, i.e. a person that has a visual problem, when you're offering property for sale, you fall under the fair housing laws, which means you have to give people reasonable access. So the idea here was if you're visually impaired, you go to the website, it doesn't have some feature that allows you to hear the offerings, the listings, you're violating potentially the fair housing law. So I'm sure real estate companies comply with this all the time, but unwittingly associations who are just trying to say, hey, owners, if you want to list your house for sale on our website, go at it. I mean, you know, or rent or whatever. That's a good resource, right? But they never made their website compliant for visually impaired people. So they were getting sued for violating the Fair Housing Act. The easy solution was don't let people list that stuff on the website anymore. But recently there was a case, and I'm going from memory here, I believe there was a recent case that said that part of the law doesn't apply to associations. I can't remember exactly, but they've tried to stop that abuse. The easy thing is just don't have people list their places for sale or lease on your internal local website. If you do, I'm not a techie, but I understand it's not difficult to turn on the talk
Audio version, yeah.
Or three, I think the ability to sue you if you didn't do that is lessened, but I would do one of the first two, take it off or turn on the feature.
Thank you. All right, another question. This is for an HOA. If the board does not hold a meeting to certify a recall, is the board member off? Board.
Yes, if the HOA board of directors that's been served with a recall that is sufficient doesn't or insufficient, they have 5 business days from the date of service, not counting the service date. They have 5 business days to hold a board meeting to either certify the recall or reject the recall. If they fail to hold that meeting within the 5 business days, the recall is automatically valid. Even if it was really invalid, it's automatic. So when you get served with a recall, you need to talk to your legal counsel immediately because there are steps that you have to take very quickly to avoid default approval of the recall, assuming you had a reason to deny the recall, like there weren't enough votes or something like that.
Right. All right, thank you. All right, let's see. If our association is in the process of updating our documents and the 7-1 changes are approaching, what takes precedence?
Well, if you're an HOA, well, again, you know, all the laws, people often say the laws always control over the documents, and people often say the documents control over the law. Neither of those statements is correct. They're both wrong. It all depends on the law and the provision of your documents. Some laws say no matter what your documents say, this is the law. For example, condominium association insurance, that's the law. Your documents cannot provide otherwise to the most part. Other times the law says, unless your documents provide otherwise, this is the law. For example, material alterations in condominiums. It says, unless your documents provide otherwise, a material alteration has to be approved by 75% of the total voting interest. But if your documents provide different, your documents will control. So as of July 1, each of these laws is going to have to be looked at. The one that comes to mind immediately is that HOA prohibits or regulates leasing. That is going to control over the document if the amendment is made after July 1. Now, again, if you get the amendment in before July 1, you don't have to worry about the law.
All right, here's a COVID question. With the COVID restrictions easing, what advice do you have for reopening fitness centers? We are currently limiting the numbers still.
Okay, we're still under emergency powers. The governor canceled some, but left others in place. The ones that apply to you, which means condos and HOAs and co-ops, you're still under emergency declaration of emergency, I believe, until about June 26th. All intents and purposes, we do not think, we thought this the 6 times he extended the emergency before, but this time I think we're all pretty sure he's not going to extend it again. So they're going to go away. So right now, you can continue to whatever degree you think is warranted. Complete opening with nothing, I don't think is smart. I guess, my advice is look to what other businesses are doing. And what I've noticed is a lot of them are still keeping distancing. A lot of them are not requiring the patrons to wear masks, but the employees are. And I think there's more frequent cleaning. So I think you should lighten up, but I would take the conservative approach. And I would rather you keep things closed down too long rather than not long enough. And I've been saying that for a year now.
I know.
But so I would watch what others are doing. I think you can still, as long as you have your emergency powers, you can do what you want. After that, it's going to be a little more difficult, but maybe you can recommend masks, you recommend this, but not mandated and things like that.
Yep. And a lot of times we'll recommend, obviously go with what the CDC says, and their CDC, not CDD, and then your local county, right?
Exactly.
Look at what your local county's going. So, Lee may be different than Collier, maybe different than Charlotte, et cetera. So are there any updates on the emotional support animals? That always comes up.
Yeah, they changed the law last year and made it a little more difficult, but honestly, no, it's still very easy to get your pet declared an emotional support animal if you do a little homework and you get a little, but there's no new laws that I know of that have made it less available for abuse.
So I like this, and this person may know you. They said, are there any laws that you wished would have gone through that didn't?
Making me king of the world? No, I don't. I wouldn't want that. Believe me, I don't want that. I don't know. I'm kind of disappointed on the emergency powers business. Most of the laws I'm glad didn't go through are bad laws. There was a whole bunch of what I'm happy they didn't go through. One of them I'll give you an example of. Early on in the session, before the session started this year, there was a big change to the official records requirements in the sense of how you complied with an official records request. And going from memory, but the proposed bill was basically the manager or whoever compiled the records would have to pull the records, make a list of each record given, and then sign an affidavit. So, you would get these requests and say, I want to see everything for the last 3 years. Well, how are you going to comply with, I made a list of every, so it was so burdensome. We're like, that is crazy. I mean, I'm glad that didn't get through. That's what I can tell you.
A question that came in live was from Jack. He wanted to know, with the COVID liability statute, is that only apply prospectively, or is it retrograde back all the way back to 2020?
No, in fact, the COVID liability statute, I think the governor signed that the first or second day of the session. It was a law. It's law now, and it was law since March. Okay, and it applies to all of COVID claims. Now, if there was a pending COVID claim, somebody had already sued you, I don't think the law is going to make them comply with that. So if you were unfortunate enough to already get sued on that, I don't know that the law would apply to a claim that had already been filed in court before the law.
Okay, I'm just reading through all of the questions that we had come in, but I think we've really almost touched on all of them. Paul asked, are we required to bring in natural gas? Going back to, people who have offered the electronic stations, the charging stations, you're not required to.
No. And the electronic charging station and gas charging station, the laws that apply to the individuals, it puts the complete burden on the individual to pay for it, insure it, engineer it, all of that. If only if you wanted to, but so if you're not planning to do it for the common areas in general, you're not required to bring a gas line and say, hey, any of those guys, we did this for you. You would not be required to do that.
Okay, and we've got another one. So some associations, so condos going to the transfer fee, right? That's $150. But associations, HOAs, I should say, a lot of times have a capital contribution or a resale fee for their units or single family homes, right? So if they have a clause in their documents that they are allowed to charge the $1,000 capital contribution fee, is this still legal?
If you're an HOA, it's legal. It's basically never been legal for a condo or co-op to charge more. People did it, and that law's pretty much been clear that it's $150 now. That's it. But HOAs, yeah, you can charge whatever your documents provide.
All right, one more question with the emergency powers, and this is a condo question. So not all owners supply a key to the association. Are owners required to provide a key to management if you're a condo?
There's no law that says owners must provide a key. What it said, what the law and the rulings from the Division of Condominium says is, if you have a rule in your condominium that owners must supply a key, that rule is valid and enforceable as long as you are requiring it to apply to everybody. So if your rules or your governing documents say the board is entitled to a key, yeah, you'd have to give them a key. But there's no law that says, no statutory law that says owners must do that, but it's a valid rule.
Yeah. Well, it helps in case there's an emergency and you aren't there, right? There's a leak,
Right.
And management's got to get in. Last question here. Can we make the owner use the communal EV charging station as opposed to allowing them to put it in their own parking spot?
No, the law says they have an absolute right, if they jump through all the hoops, to put it in their limited common element or individually assigned parking space. So there's a difference there. A limited common element is essentially an appurtenance to the unit. When you sell the unit, that space goes with that unit. It's basically tied to the unit legally. They have an absolute right to put it in that space. The law was expanded this year to say, if you have a non-limited common element space, but they are assigned more or less permanently, it doesn't travel with the unit when it's sold, and it could be reassigned differently. But if that's your space, they're going to allow you to put it in there too. But if it's just general free-for-all parking, like you can park anywhere and nobody, no, they wouldn't have a right to put it in that space.
All right, hold on. I think one more came in. I thought we were getting, great class. Scott, so thank you, Scott. Scott says great class.
Thanks.
All right, well, thank you so much, Richard. Great information. I will be sending out the slides so everybody has a copy and with Richard's contact information should you have any further questions or for myself. Thank you, Richard, for your time.
The opportunity.
Yeah, always nice and a pleasure to see you. So have a great rest of your week and everybody have a great afternoon.
Okay.
Thank
Okay.
you.